Okay, so my role is to say welcome, so I just did that. Welcome to the 19th annual meeting of the International Society of New Institutional Economics. I'm Henry Smith, the program chair for this year's meeting, and we are totally delighted that you can join us here at Harvard Law School for this year's conference. I'm especially pleased to welcome you to Wasserstein Hall, where we are sitting right now, which is part of our newest building complex at the Harvard Law School. We're fortunate to be able to have the entire conference under one roof, albeit a very big roof. And I'd like to take this opportunity to thank the Harvard Law School itself, and especially Dean Martha Minow, for the incredible support, not just this lovely building, but also the generous financial support and staff support for this year's ISNIE. The staff has done an amazing job. Harvard Law School will celebrate its 200th birthday in 2017, at least that's the official line. And we managed to squeak this first ISNIE at Harvard Law School in under the wire. We have a terrific conference this year, as you can see from this year's program, which you already have in your packets. The program committee faced a daunting wealth of hundreds of papers, which were excellent. And through the superb efforts of our program committee listed in your program, we have 196 papers and 7 posters being presented over the next 2 days. This year's program is, in my biased opinion, worthy of the great ISNIEs of the past. At the same time, this year's meeting also is a landmark in that we're changing the name of the society and launching a new website. We'll have a lot more about that at the business meeting, so if you thought that the business meeting sounded boring and skippable, please revise your opinion, because this will not just be any business meeting. It will be the birth of a new era right before your very eyes. For now, I can say that the breadth and depth of the papers in this conference that reflect a wide variety of perspectives, both disciplinary and methodological, for analyzing institutions and organizations is going to be the hallmark of the program as usual. Just before we start, I think it's not bad to look backward a little bit. I looked up the first newsletter of the Society back in 1998, and Ronald Coase and Douglas North offered a joint, quote, invitation to join ISNIE, which is quite timely. This will, I think, sound quite fresh. So Coase and North said the following: we invite you to join the International Society for New Institutional Economics, which has been formed to bring together people working in this area, particularly those doing empirical work. Scholars working in applied NIE include political scientists, anthropologists, sociologists, and lawyers, as well as economists in such diverse fields as economic history, law and economics, public policy, industrial organization, business, and microeconomics. The Society aims to bring together scholars in countries all over the world who are working on transaction costs, contracting, political rules of the game, the rule of law, norms and culture, and so on, and who pursue these interests using standard scientific methods. While theorists are very welcome, the main emphasis is empirical. And in a separate statement, Coase very poignantly added, and more poignant now than as you'll see in a moment, I have no doubt that members of our society, American and non-American, will play a significant part in bringing about the restructuring of economics that is needed. It is impossible to predict exactly what will be accomplished, and I, personally, will never know. But many of you, I feel sure, will see in your lifetime significant improvements in economics brought about by the work of our members. Indeed, I believe we're well along the path that Coase just described, and this year's participants, as a measure of that, hail from 29 countries on 5 continents, and approximately 53% of the participants are affiliated with institutions outside of the United States. Disciplines and perspectives represented include not just economics, but also political science, management, psychology, sociology, history, anthropology, law, statistics, and biology. So it's with this in mind that I am personally totally delighted to introduce our first keynote speaker of the conference, Professor Michael Whinston of MIT. Michael Whinston is the Sloan Fellows Professor of Management in the Applied Economics Group at MIT Sloan and Professor of Economics in the Economics Department at MIT. He has previously held professorships at Harvard and at Northwestern. The quality and range of his research make him an outstanding keynote speaker for the Society, as you will see demonstrated empirically in just a moment. He has done important and foundational work in microeconomics and industrial organization, including firm behavior in oligopolistic markets, antitrust, game theory, the design of contracts and organizations, law and economics, and most recently, health economics. Indeed, his work modeling property rights and transaction costs, of which we'll hear in a moment, has been an important source of insight and rigor in this area. In addition to producing numerous excellent research papers, Professor Whinston has also reached a wide audience through co-authoring the leading graduate textbook in microeconomics entitled Microeconomic Theory, and authoring lectures on antitrust economics, and most recently he co-authored Microeconomics and Intermediate Microeconomics text. So today we are his appreciative audience, and I give you Michael Whinston.
Okay. Does this work? Yes? No? Up. Talk louder. Move it up. Okay. All right. Thank you very much. It's a pleasure to be here. Actually, as Henry was saying this, the introduction to the society, I thought, there isn't, I guess about the importance of empirics, which I do think is very important. I guess one way to put this is I will demonstrate something he said empirically, I hope, but it won't be empirically. Today's talk, some of my work is empirical, but today's talk, I'm afraid won't be. But hopefully it will inspire some. So we'll see. Okay, so the work I'm going to talk about today is about property rights and the efficiency of bargaining. It's talking about basically joint work with Ilya Siegel of Stanford. So I guess property rights in some sense are certainly and I think arguably the central institution in capitalist economies. What they do is they specify a default. So they basically there's a default specified in terms of an allocation, and they leave the details of the final allocation up to negotiation and bargaining. Okay, so if coming back to Coase, as many things do, from the Coase theorem, we all are used to the idea that if parties can bargain perfectly, while property rights are very important, the particular allocation of them isn't for efficiency. That is, regardless, the Coase theorem, or theorem, quote unquote, depending on how you feel about it, tells us that regardless of the initial allocation of property rights, if parties can bargain perfectly, we will get to an efficient allocation. Now, the thing is that for a long time, we've actually known that if parties can't bargain perfectly, and in particular are bargaining under circumstances of asymmetric information, which we think is often the case, that statement is not true. So if you go back to the famous Meyerson and Satterthwaite theorem, the theorem posits a buyer and a seller, and they're bargaining under circumstances of asymmetric information. And what that theorem tells us is that very generally you can't achieve efficiency in bargaining in that circumstance. But just 4 years later, Crampton, Gibbons, and Klemperer, of whom we have at least one here, if not others aren't hiding in the back, showed us that partnerships are sufficient under certain circumstances, and in their model, sufficiently symmetric allocations of shares, partnerships could be dissolved efficiently through bargaining. Now, if you think about what that's telling you, it's telling you that Meyerson-Satterthwaite is a setting with extreme property rights. One person is the seller, they own the good to start with. The other is the buyer, they own nothing to start with. On the other hand, the partnership is a setting where the initial ownership structure is more evenly distributed. And what we see is, in one case, the Meyerson-Satterthwaite case, we can't achieve efficiency. But in the more symmetric case, where we have a different property rights allocation, we can. Right? So we know that in general, the allocation of property rights when there's asymmetric information can be important for the efficiency in the end. Now, so what this project with Ilya is really trying to do is look at what the optimal allocation of property rights is when parties are bargaining under asymmetric information. Okay. Now, I should stress, sitting next to Bob Gibbons is Oliver Hart. So, this is quite different than what the Grossman-Hart-Moore paradigm is looking at in terms of the efficiency the efficiency effects of property rights. There, basically, it's about ex-ante investments, and there's a incomplete contracting to start with. We are going to bargain perfectly in the end, but ex-ante we can't bargain, okay? And we end up getting inefficiency in investments. Here it's going to be a different story. It's not going to be about investments. Rather, we're going to have asymmetric information bargaining, and the inefficiency is going to come from the fact that bargaining doesn't, sometimes breaks down. We sometimes don't get to the efficient outcome, all right? So that's kind of by way of, in some sense, the economics or institutional background. This same question, not surprisingly, has a significant place in legal scholarship. And so going back to a very famous paper by Calabresi and Melamed, they focused on drew attention to the fact that in the law, property rights are enforced in different ways, in different circumstances, in various circumstances, or as they would call them, entitlements, okay? And in particular, they drew attention to the fact that sometimes property rights are enforced by what are called property rules. In other cases, they're enforced by what are called liability rules, okay? Now, what's the difference? Well, imagine you own a bicycle, and I come along and I take it. Property rule is going to say, a court's going to step in and physically return the bicycle to you, okay? A liability rule, in contrast, is not going to physically return the bicycle to you. Instead, it's going to force me to pay you a damage for taking your bicycle. And those are two different property rights regimes. And what Calabresi and Melamed were interested in is why would we sometimes have one or sometimes the other, and which one's best and in which circumstances. So what they said was, well, when parties can bargain, property rules, which are like standard simple property rights, are great. They achieve efficiency, basically echoing Coase. Okay? We'll come back to this in a second. On the other hand, if parties can't bargain, liability rules have a really nice feature to them. What they would call they're market mimicking. All right? And in particular, if you think about that liability rule, suppose I have to pay you a damage of $100 for taking your bicycle. One thing that happens when we have a liability rule is whether I take it or not, if I'm rational, will depend on what my benefit is from the bicycle. So as a result, the final allocation will be responsive to my value in a way that it wouldn't be if we just said that you're the owner and I don't get the bicycle. Okay? So in that case, they would say, well, if you can't bargain, liability rules have a good feature to them. All right. Following on that, more recently, some other authors, Ayers and Talley, Ayers, Kaplow, and Chevelle, have pointed out that liability rules might also be very good in cases where there's bargaining, but it's imperfect. We're not all the way to the Coase theorem perfect bargaining setting. So, for example, Kaplow and Chevelle would say, well, you just told me that if there's no bargaining, liability rules are better. They're market because they are responsive to the outcome is responsive to values. So if we're a little bit away from no bargaining, we can bargain, but it's very imperfect. It seems like we should still find that liability rules are best. In some sense, liability rules have a head start. Okay? And actually, if you think about the other extreme at perfect bargaining, the Calabresi and Melamed said, well, property rules are really good then. But actually, the Coase theorem tells us that liability rules are perfectly great then too, because it doesn't matter what you start off with. So maybe actually what this suggests is, well, maybe liability rules are better all the time. Okay, they're equally good when you have perfect bargaining, and maybe but it's not clear, and as a result, there's a horse race to be run. Okay, so now let's think about that horse race just for a minute, just to set up a couple things. So if you think about that horse race, actually, simple undivided property rights like you own the bicycle or I own the bicycle are special cases of liability rules. Because you owning the bicycle, that outcome where you get the bicycle all the time is equivalent to a liability rule where I have to pay you $100 billion if I take your bicycle. I just won't take it then, and you will have it all the time. Okay? At least if I'm rational. All right. So So there actually isn't a horse race to be run if you are comparing simple undivided property rights to general liability rules that can have any damage payment. Actually, in that case, those liability rules would dominate. So if you want to have a horse race here, there's one of two things you can do. On the one hand, you can think of more general kinds of property rights, generalize the idea of simple property rights to what I might call fractional property rights or continuous property rights. So in some settings, it isn't just whether you own the bike or I own the bike. So if we're thinking about pollution, it isn't that I can, the firm may not either not be, two options are the firm can't pollute at all or it can do as much as it wants, but another option is we cap the amount of pollution at some intermediate level, okay? So that would be, move us away from that simple undivided property right, and there'd be a horse race to be run against liability rules. Partnerships, like in Crampton, Gibbons, and Klemper, is another intermediate way in which you have intermediate property rights. Another thing that generates intermediate property rights is just legal uncertainty. Like, it's not quite clear who's going to be declared to be the owner if we go to court. There's a probability. Okay? So we can have that kind of horse race, which I would call an unrestricted horse race. Fractional property rights against any liability rules with any damage payment. And the other kind of horse race you could have is you could be thinking about undivided simple property rights, like which one of us owns the bike for sure, but instead of against any liability rule, against what I would call traditional liability rules, which would be liability rules with expectation damages, which are the typical kind of damage enforcement for a liability rule, which is if I take your bicycle, I have to pay you the damage payment is your expected harm. And so we could ask which of those two things is better as an institution. So the literature has looked at these horse races, in particular the legal literature, with very, very particular examples and bargaining procedures. So what we've tried to do is to step back and do things in a more general way. And given our backgrounds, what that more general way is a mechanism design approach. Okay? And in particular, what we ask is, what's the best allocation of property rights if bargaining is optimal, quote unquote, given informational constraints? If bargaining was set up to be as efficient as possible given the informational constraints. That is the asymmetric information that exists. Now, when we're thinking about the best allocation of property rights, it turns out that there's more than one way of asking that question of what's best. Okay? So one way is to go back to, if you go back to Meyerson and Satterthwaite, what Meyerson and Satterthwaite showed was that that you can't achieve efficient bargaining if we have to satisfy, if the budget is balanced between the buyer and the seller. If any payment the buyer makes goes to the seller, there's no outsider subsidizing. Okay? That was essentially what the key thing was. That is, with asymmetric information, at enough subsidy, you could achieve efficiency. So one way to measure what the best property rights are is to ask, well, what property rights minimize the subsidy you would need in bargaining to achieve efficiency? Okay? So that's one thing you can ask. Its advantage is that we're able to have actually get very clean results, all right, which are not only clean but in some, I'd say, fairly striking. The disadvantage is often we don't think there's an outsider who's going to subsidize. And in that case, a different criteria you might ask about is what's the expected surplus that can be achieved if you are satisfying budget balance. And let's pick the property rights that maximize that expected surplus. So in the work that we're doing, we look at both. Today, through this talk, I'm going to mainly talk about the first of those. The second of those is much, much harder, and our results are much more limited, and I'll describe them briefly at the end of the talk today. I should also say, through almost everything I do, and everything, if time, perhaps depending on how time is going, I'm only going to talk about this property rules versus liability rules, although the same kind of approach you could take to thinking about other kinds of property right institutions. Okay. So, let's first talk about the unrestricted horse race. So first, let me say something about fractional property rights. So in a wide range of cases, it turns out that fractional property rights can make efficiency bargaining possible. So I've talked about one example already, which was Bob's paper on partnerships. That was one example of achieving efficiency with fractional property rights. In earlier work, Ilya and I showed that actually efficiency, under very, very general conditions, efficient bargaining is possible if the initial property right is what we call the expected efficient allocation. Okay? I'll say in one sentence what that means, and then I'll try to illustrate it with an example. So the expected efficient allocation would be, let's take the bicycle. What share of the bicycle should you own? We're going to have a fractional ownership of the bicycle. You are going to own a share of it, and I'm going to own a share to start with. What share should you own? You should own the share which is the probability with which you're the efficient owner of the bicycle. That's what I mean by the expected efficient allocation. So let me give you an example not involving the bicycle. Can you guys see here? Yes? Okay. All right, so it's going to be a pollution example and going back to the origins of thinking about property rights. So we have Alpha, that's a manufacturer called Alpha Corporation, and it can pollute putting toxins in a river, up to 1 ton of toxins. Okay, maybe this is per day. Its benefit is X, and I'll assume that it's uniformly distributed between $0 of benefit from polluting and 100. Its average, of course, is therefore $50 from pollution, from being able to pollute. Downriver is Ms. Smith that has a fishery. It has to be a fishery. It's a river. And Ms. Smith's harm is Y. And the probability density for that harm, Y, is given by the density function A, Y over 100 raised to the A minus 1, where A, in this example, will be 3/2, and Y, the harm, is also between 0 and 100. And in case you're not immediately doing the integration, the average harm for Ms. Smith is 60. Okay, over all, if the river is polluted, a ton is polluted, the harm on average will be 60 to Ms. Smith. Okay, so here is a picture of the two density functions. The dash is the uniform distribution of alpha's benefit. The upward sloping solid line is the density function of Smith's harm, and it's increasing at larger harm levels, which is why why Smith's average harm of 60 is bigger than the average benefit for alpha of 50. Okay, so what's the efficient outcome here? Well, the efficient outcome is simple. You want a ton of pollution to be put in the river if and only if the benefit to alpha is bigger than the harm to Smith. Okay. The probability that that's true in this example, again, I'm not expecting you to quickly have done the calculation, is 0.4. So 40% of the time, it's efficient to have pollution. And the average surplus that's generated by that outcome in this example is 11.4. You'll see 11.4 come up a lot in the next 35 minutes. Okay? So what Ilya and my result says is efficient bargaining is possible if alpha is entitled to pollute 0.4 tons of pollution. Okay? Which is the average of the average level of pollution in the efficient outcome. Right? 40% of the time we should have a ton of pollution. 60% of the time we should have no pollution. So the average is 0.4. Okay? So in general, there is a fractional ownership that allows bargaining to end up being efficient, to achieve an efficient outcome. Let's now turn our attention instead to comparing it to a liability rule. Okay. So for a liability rule, we show that if two conditions hold, there's a simple formula for the required subsidy to achieve efficiency. And if that subsidy is not positive, if that subsidy turns out to be 0 or negative, it means we can achieve efficiency at a given allocation of property rights. If it's Positive, it means we can't, and that's the measure of how much subsidy we need. So what are the two conditions we need? Maybe I'll say it twice because it's a little hard to take in. So the first thing is that each individual has a possible value for the right, maybe it's the bicycle or the right to pollution, that is, or in mechanism design language, has a type for whom it's efficient for that individual to just stick with his initial property right allocation, regardless of the values, or the benefits or the harms anyone else has. Okay? So when somebody has that type of individual, we call an efficient opt-out type. So that type can opt out of the bargaining, and the outcome is efficient regardless of the other guy's value. I'll illustrate this in a second in an example. The second thing is, in the event no deal is reached, the second condition we need is that the efficient opt-out type for an individual is also the type that when he opts out leads to the worst possible outcome for everyone else, for the other people. So that is, given that Mr. 1 opted out, or say in our example that Alpha opted out of bargaining, that efficient opt-out type is gives the lowest possible payoff to Smith among any, in the case of opting out. All right, and if that's the case, we call that type for Smith, for Alpha, an adverse efficient opt-out type, adverse to Smith. So let me give you an example. So let's think about a liability rule where Alpha chooses whether to pollute, and if Alpha pollutes, pays a damage of D. Okay, D dollars. What I want to do is tell you what the adverse in fact, in that example, each of these, both Alpha and Smith have an adverse efficient opt-out type. I want to tell you what they are, and just in doing so, explain to you what the logic is. So how you can see that. So let's think about Alpha, and my claim is that Alpha's adverse efficient opt-out type is when Alpha's benefit of pollution in this example is 100. The highest possible benefit. Okay, now why is that? Well, let's first ask why it's efficient. Why it's an efficient opt-out type. Well, if Alpha opts out and refuses to bargain and just sticks with the property right, which is the ability to choose whether to pollute and pay a damage of D, what will Alpha do if his value is 100? When he opts out of bargaining, what he's going to do is choose to pollute, because his benefit is 100, but he only has to pay a damage of 50. So he'll pollute, for sure, okay? But it's also efficient that type of Alpha pollute, because that type has a benefit of 100, and no matter what Smith's harm is less than that benefit, because Smith's harm is between 0 and 100, okay? So that, under the liability rule with a damage of payment of 50, Alpha's adverse efficient opt-out type has a benefit of 100. Let's think about Smith. My claim for Smith is that Smith has an adverse efficient opt-out type of having a harm equal to 50. Okay? Why is that? Well, suppose Smith has a harm of 50 and opts out of bargaining. What's going to happen? Well, Alpha has this liability rule, the ability to choose to pollute at a payment of 50, for a damage payment of 50. That means that under the liability rule, Alpha will pollute if his benefit is bigger than 50, and not pollute if his benefit is less than 50. Well, when Smith's harm is exactly 50, that's efficient. And it's efficient regardless of what Alpha's benefit is. Moreover, it's immediate that it's an adverse type, because actually Alpha's payoff under the liability rule in the case of Smith opting out doesn't depend on Smith's value. Smith's harm. It only depends on the damage payment that has to be made. So in this case, Smith's adverse efficient opt-out type is 50. So the main thing I'm illustrating here is how to think what I mean by adverse efficient opt-out type, and that in this example of a liability rule, these two conditions I said are satisfied. And actually they're satisfied I could have picked other damage payments, and The adverse efficient opt-out types would have potentially been different, but they would have existed, and we would have satisfied our two conditions. And what our two conditions tell us imply is that the subsidy that's required to achieve efficiency takes the form that's up on the screen now. It's got three terms. The first term, the first term is, I didn't realize that ended. Okay. Luckily, I'm better on this podium than I am surfing, where I cracked my rib. All right. So the first term is actually just it represents the expected surplus under efficiency. In the example, it was 11.4. Okay. The second term is agent 1, let's say alphas, pay off when agent 1 opts out, and when agent 2 has the adverse efficient opt-out type, which I'm representing by this theta 2 hat. Okay? He's trying to keep me from injuring myself and suing the law school. Okay. I should fall a few more times. They obviously have a lot of money. Okay. Okay, and then the third term is just the same thing, but for agent 2. Agent 2's payoff in the event one of them opts out when agent 1 has the adverse efficient opt-out type. Okay? So let's apply this to see what the subsidy is in the case of the liability rule with a damage payment of 50, okay, as a start. So here is what the calculation is. The average efficient surplus is 11.4. We subtract from that alpha's average payoff in the event, under the liability rule, that is if one of them opts out, when Smith's harm is 50, which is Smith's adverse efficient opt-out type. And I noted before that alpha's average payoff actually under the liability rule, where alpha's choosing whether to pollute, doesn't actually depend on this 50, so we'll just get rid of that. Okay? So my claim is that number is 12.5. Why is that? Well, under the liability rule, alpha pollutes if his benefit is bigger than 50. Okay? What's the probability of that? Probability of that is a half. When he's conditional on choosing to pollute, what's his benefit, net benefit? Well, on average, he's somewhere between 50 and 100. It's a uniform distribution, so his average benefit of pollution in those cases is 75. He pays a damage of 50, so his net benefit on average when he chooses to pollute is 25. And he does that half the time, so his average overall, his average payoff is 12.5. The last thing we're going to subtract is Smith's average liability rule payoff when alpha has a $100 value. So this is Smith's average payoff in the event one of them opts out when alpha has his adverse efficient opt-out type of 100. Well, that's simple. When alpha has a benefit of 100 under the liability rule, he pollutes. And when he pollutes, he causes a damage of an average of 60 to Smith, and he pays a damage of 50. So Smith loses out by 10. So we see that that's negative 10. So the first thing minus the second minus the third equals 8.9. So that's the subsidy that you need to achieve efficiency in bargaining. One thing to note is it's positive. So with this liability rule, you can't achieve efficiency. Okay? Remember, the fractional property right where I gave the 0.4, I let alpha pollute with up to 0.4 tons, did achieve efficiency. This thing doesn't. And actually, I'll hopefully convince you later that there's no liability rule here that can achieve efficiency. Okay? So if you run this unrestricted horse race of any fractional ownership property right versus any liability rule, the property right wins. Okay? All right. So that's the unrestricted horse race. Let's now think about the restricted horse race. So let's first think about so the restricted horse race, just to remind you, is going to compare simple undivided property rights like alpha gets to pollute as much as it wants. That's one. The other one is alpha doesn't get to pollute at all. okay, as the property right. Those are the two simple undivided property rights. So we can use the same formula to say, what's the subsidy required? Well, this is a much easier calculation than what we did a minute ago. In the case where Smith has the undivided property right, that is, no pollution is allowed, the efficient outcome still gives a payoff of 11.4. The payoffs in the event of no pollution, which is what happens under the simple undivided property right if someone opts out of bargaining, are just 0 for both of them. There's no pollution that happens. And we've normalized that to be a payoff of 0. So the subsidy required is 11.4 to achieve efficiency. On the other hand, if we allow alpha to pollute as much as alpha wants in the event of opting out, then what's our formula? Well, same first line, 11.4 for the efficient surplus. Then alpha's average payoff from polluting is 50 as an average benefit. That's what in the event of a breakdown of bargaining or opting out from bargaining, alpha will pollute because he can pollute for free. Okay, he has the undivided right to do it. And so his benefit will be 50. Smith's average payoff will be minus 60. That's Smith's average harm. And actually, what we see when we do the calculation is the required subsidy in that case is 21.4. So in this example, between these two things, it's better to give Smith the undivided property right. Okay? So between the two undivided property rights, Smith should have it. We should not allow pollution in this example. Now, there's actually a much more general fact that this is reflecting, which is if you think about that formula in the event of a simple property right, with simple property rights, in the event of a breakdown of bargaining, you just consume your property right. You just experience your property right. You don't care what the other guy's value is, okay, or harm. You just pollute if you're and have your benefit if you're alpha, and experience your harm. Experience your harm if you're Smith. So, put differently, these theta 2 hats and theta 1 hats disappear from this formula. And what you can see from this is you want to pick the property rights that maximize that expression. Well, that's the same, since this is just the efficient surplus and doesn't depend on the property rights. Minimizing the subsidy is actually the same as maximizing the sum of the last two terms. And the sum of the last two terms is just the values at the property rights allocation, the expected values. So what you want to do is, in the event of in the case of undivided property rights with two agents, not just in this example, but in any example, what you want to do to minimize the subsidy is allocate the good to maximize the expected values, expected surplus in the economy. And what does that mean in our example? It means do no pollution because on average, Smith's harm was bigger than alpha's benefit. Okay, 60 was bigger than 50. But that's true not just in the pollution example. It's true in any case where this is the right subsidy, where our two conditions were satisfied, so we had this subsidy formula, and there were two agents. It would be true. And what's striking about this is, notice this is exactly the same rule that you would have if you were allocating the property right in the best possible way under the assumption there was no bargaining at all. Okay? So allocation of simple property rights with two agents is actually the optimal thing to minimize the subsidy is exactly the same as if there was no bargaining. Okay? And what we're going to see is that carries over to liability rules too. All right? So this is what we want to do with simple property rights. Let's look at the liability rule. So what I'm going to try to convince you of is that the best liability rule actually has expectation damages. Now, those of you who remember or know or whatever your law and economics, like Capello and Chevelle have a show that quite a while ago that if there's no bargaining, the best liability rule is expectation damages. Okay, that achieves the best you can do. And what I'm going to show you is to minimize the subsidy required for efficiency when there is bargaining, you do exactly the same thing. Okay. All right. So let's just do the calculation. Now I'm going to just break it up. First, I'm going to look at any damage payment that's less than 60. 60 is the expectation damage here. It's the average harm for Smith. Okay? So if the damage payment is less than 60, the first line is still our 11.4. The second line is alpha's average liability rule payoff, and that's just the probability alpha exercises, which is 100 minus d over 100. It's a uniform distribution for alpha. And the average gain that alpha has by exercising is 100 minus d over 2. That's just, in our example of 50, this was a half, and this was 25. Okay? And then we subtract Smith's average liability rule payoff when alpha has a benefit of 100. And the reason that's still alpha's adverse opt-out type is when D is less than 60, Smith doesn't want exercise to happen because the damage payment is less than the harm on average. So the worst thing that the worst type for alpha to have when we have an opt-out is 100, which always exercises. Okay, in that case, alpha's net payoff is D. We're going to have exercise. We're going to have pollution. Smith will get a damage payment of D, but suffers harm of 60 on average. And then when you add this all up, you get a formula for the subsidy, and it turns out that subsidy is decreasing in D all the way from 0 up to 60. So out of all of these possible liability rules, the one that minimizes the subsidy between 0 of damage payments that could be between 0 and 60 is 60, the expectation damage. And I won't go through the similar calculation on the other side, where for D is bigger than 60. The only change here is that the adverse opt-out type for Smith is now 0, for alpha is now 0, because now Smith loves it when pollution happens and the damage is paid, because the damage is bigger than 60. And so the worst thing for Smith is to not have pollution under the liability rule. So you do this, and what you find is same idea, going from a damage of 100 down to a damage of 60. The 60 is the value that minimizes the subsidy. So from either way, what you see is 60 is the best, and 60 is the expectation damage. Okay? Now notice two things. First of all, okay, yes, it's expectation damages, and therefore it's exactly what we would have said if bargaining was impossible. If we just had, we're back to Kaplow and Chevelle and just never had any idea that we could be bargaining, we would have said do expectation damages. The other thing it implies is that actually a traditional liability rule is better than either undivided property right. So we already know that because damage of 0 and damage of 100 are the simple property right, are equivalent to the simple property right. So we've just actually resolved the horse race. We've seen that picking alpha to be exercised and giving an expectation damage award would be better than the either simple property right. Okay? And actually, there's also, I didn't show you this here, but when you put 60 in here, you'll see the subsidy is positive. And earlier, remember, I claimed that there's no liability rule that can achieve efficiency? That's how you show it. Okay. So I haven't totally come to the full thing on the liability rule, in that I haven't yet asked, well, maybe Smith should be the one to exercise, not alpha. Smith should have a right to insist on pollution but pay for it as an option. So you can go through that option as well and calculate. And the best thing for Smith, if Smith has the option, the payment should be 50, the expected benefit to alpha, same idea. And if you ask which of them should be the one to have the option, the answer is exactly the same as if it was no bargaining. So everything here turns out to be exactly the same as if there was no bargaining at all. Okay? I won't go through the calculations. Okay, so in this case, you can actually show that alpha is the best chooser, and as I said, it's the same as when bargaining is impossible. Okay, let me just say two other quick things on the subsidy, on using the subsidy formula, and then something very quick about looking at second best surplus instead as your criterion. So the first is we've been talking about property rules and liability rules, but you can use this to think about other kinds of property rights. And more generally, you can think of property right mechanisms, in fact. So simple property rights are just they specify the default. Liability rules, in some sense, are like option contracts. One party gets to choose what the default allocation is going to be, as knowing their own value. But you can also imagine more complicated games in which both parties have some influence on what the default is going to be, what the outcome will be. So Ayers, for example, in his book, looks at something he calls the dual chooser rule, where I have the right to take your bicycle and pay you a damage payment, but if I do it, you have the right to actually return the damage payment and get your bicycle back. Okay? So that's like a game where both parties take actions, and you can analyze that using this kind of approach. I won't do it or go into it, but let me just leave it at that, all right? The second thing is everything I've done so far, kind of following back to the classic examples and this legal literature, has just two parties. If you start doing this with more than two agents, what you'll find is this subsidy formula starts involving coalitional values. And it's no longer true that the best allocation of the best property rights are the same as when bargaining is impossible. Okay? So that kind of very striking equivalence starts to break down. All right, does break down. So for example, if you introduced a Mr. Jones who also had a fishery, it turns out like when you're looking at the optimal liability rules, suppose there's a liability rule and there's a damage payment to Smith if you pollute and a potentially different damage payment to Jones. It turns out that you can show it's always optimal to have the sum of those damage payments equal to the expected sum of harms. But it's not true that you want to necessarily have each person's damage payment be equal to their expected harm. Okay, let me just kind of wrap up by saying something about the other criteria, the second best surplus criterion. So as I said in the beginning, comparing property rights in this way is much harder. Okay, it's just, and our results, as a result, what we're able to show is definitely more limited. So for example, what we've looked at focuses only on the two-agent case. Okay, so what do we show? Should I say anything about why it's harder? No, it's harder. Okay, characterizing the optimal bargaining mechanism is just a lot harder. Okay, all right. So the first thing is, if you look at fractional property rights in the second best, remember I showed you that there's very generally there's a fractional property right that achieves efficiency, the expected efficient allocation. So, which is typically an interior, it's going to be an interior outcome. If you start with simple undivided property rights, as you move, say in a partnership towards shares that are closer and closer to the expected efficient allocation, the expected second best surplus rises monotonically. So as you get closer to that expected efficient allocation, actually there's as Bob's paper showed, there's a region typically where you can of property rights that do achieve efficiency, one of which is this expected efficient allocation. As you get closer to that region, things improve. Okay, but in contrast, that's not true with the liability rule. With a liability rule, perhaps surprisingly, if you start for any distribution of values, benefits and harms or values, if you start at a simple undivided property right and move a little bit towards something that's closer to the expectation damages, things get worse at first. So this is a graph for the case where both agents have, there's uniform distribution. So, Smith's harm, Alpha's benefit and Smith's harm are both uniformly distributed. And this is the expected surplus in the second best as a function of D, the damage payment. And what you can see is it first goes down before it goes up. Okay? So being close to an undivided property right is worse than having an undivided property right. And that's actually a general property. Okay, it doesn't depend on the uniform distribution. If someone wants to ask me the question later, I can explain why, okay? But, all right. But I'm gonna, yeah. You have to be willing to pay the strike price for that option or the damage payment. You have to be willing to interested enough to ask the question. All right, rather than me imposing it on you. Okay, so the other two things that you can show, when you're looking at liability rules, when the party with the option to choose to pollute, say alpha, if alpha has the right to pollute, if alpha has a uniformly distributed benefit, okay, then actually expectation damages are optimal, are still the optimal liability rule. But in general, it's not the case that expectation damages are optimal. So like numerically, we solve a bunch of examples numerically, and what you can show is that in general, the optimal liability rule that maximizes the second best surplus is different than expectation damages. Okay? Now that said, what's really intriguing, and we don't have any proof, nor do we quite know what to do, is that it's always very, very close in every example we've looked at, okay? That it's always the case. Every example we've looked at, the optimal damage is extremely close to the optimal, to the expectation damage level. But I guarantee you it isn't that, and we're completely convinced it's not just numerical error. Because in examples where we can characterize what's optimal, like in cases where the active guy is uniform, our numerical stuff hits it on the nose. Okay, so it's kind of an open question, and I think intrigues us, but we haven't been able to figure out how to, show. The conjecture would be that there's some bounding argument that, that expectation damages is never never results in a bigger inefficiency than some bound. But it's just a conjecture. So with that, I guess I'll stop, and we have still, I guess, 5 minutes if anyone has any questions. Okay. Any way you want to do it.
Yeah, so we have a rule 1 and 5 for this. We'll just see how it goes. But when are you calling people? I don't have any particular advantage.
Okay.
Thank you very much. I have two little questions, one technical one and one more general. The technical one is, in your example at the beginning, the damage to Smith was concave in the damage.
The damage was what?
The damage to Smith was concave in the
Yeah.
damage as far as I get it. And it seemed to me.
You mean the probability
Yes.
density? Okay.
So in that, it seems like in contrast to the benefit of the other party of alpha, which was linear, like due to the uniform distribution. And so here the simple question is, because we had some general statements of that, like how generalizable is that, and like
Okay.
So that's one point.
Right. So I guess what I said, but it depends what the results were. But this point that in the two-agent case, the best undivided that if you're looking at undivided property rights, the best thing is exactly what you would do if you didn't have bargaining. Just give the right to the person who values it on average the most. That's completely general. What's also completely general is the optimal liability rule is exactly the same as if bargaining was impossible. And what's also completely general is that between those two things, the choice is the same as if we had no bargaining. All with two agents, as I said.
These 50, 60 comparisons depended a lot on which.
So the fact that it was 50 and 60 did, but if I change the distribution, suppose I change the distribution so that alpha's harm was 70 instead of 50, while alpha's benefit was 70 instead of 50, while Smith's harm was 60. The optimal undivided property right would have been instead, it would have flipped, and it would have been let alpha pollute as much as it wants. Rather than, that would be better than no pollution. I'm not sure I'm not sure whether the optimal, which of the two parties would optimally have the liability rule. You'd have to calculate that. So, we'd have the option. So.
If I may, kind of a second one, which is a bit more general. As long as you assume away all kind of, say, enforcement costs or kind of transaction costs as well. But what if there is a court or some other enforcement institution and that kind of the costs of the transaction cost of using that institution kind of is a function of the complexity of the regime that you're suggesting, right? So,
yes. It was completely costless to both force me to give back the bicycle or force me to give money. And so there was no enforcement cost difference between those things. And in practice, maybe there is. And I mean, I have no idea what that difference is. It's for people like Henry, or maybe you, I don't know. No, not you, okay. To say something about, so this is really talking about just one piece of what you may want to be concerned about. So. Yeah.
Could you speculate a little bit about more than two agent case?
Well, I can more than speculate. I mean, in the case of well, it depends what you mean. In the case of the subsidy criteria, I have the formula, and we've worked through a couple of examples. It's just the results are not. In the two-agent case, the results are just very striking. Like I can make a statement like it's always exactly like if bargaining was impossible, which is a very clean general statement. In the bargaining case, at least so far, in the more than two-agent case, we have the formula. The question is, can you make some general statement like that? And what is optimal? The optimal allocation turns out to depend. Depends on things that are intuitive, such as are certain agents substitutes or complements for each other? And if they're substitutes, then it can be good to split the ownership because then they kind of compete with each other in the bargaining. And we kind of illustrate that in examples, but I don't have some similar general thing. In the case of the second best criterion, I don't even have any idea, because when this thing about it being hard to, it's hard to even characterize what the optimal bargaining mechanism is. And so we've done that for two, but I don't know how to do it for more than two. So, for the economists in the room, now I have the not quite given permission to say this. So what's difficult is, like in Meyerson and Satterthwaite, the optimal mechanism is, what makes the optimal mechanism relatively easy is that you know which agents are least likely to want to participate in the bargaining, who's most likely to opt out. The seller who has a value of 1 is the seller who least wants to participate. Value of 100. Well, in Meyerson Satterthwaite, where it's between 0 and 1. And the buyer who has a value of 0 is the guy who's least interested in participating. But when you have these general property rights mechanisms, it's not quite clear who is least likely to want to participate. And so given who's least likely to participate, that affects what the optimal allocation rule is for the mechanism, but the allocation rule affects who's least likely to participate. So that's what's hard. Okay. Thanks very much.
Thank you very much.